think we're welcoming back to July's Land Conservation and Development Commission meeting. We just finished our item 6 and 7, which was a bus tour called Tour of Portland's Discriminatory History by the Fair Housing Council of Oregon.
Just a moment.
Okay. Should I repeat what I said? Yes, please. Okay. So welcome back to the July meeting.
Take three.
Welcome back to the July meeting of Oregon Land Conservation and Development Commission. We have just finished item 6 and 7, which was a very impactful tour that the Fair Housing Council of Oregon just gave to our commission and other invited guests, and led by our Commissioner Lazo. And the tour was called the Tour of Portland's Hidden Discriminatory History. And I would, I don't think I can summarize the impact, the emotion, knowledge that we learned in the last couple hours of this morning. But I would say that I think all of our lives have changed by the lived experiences we heard from the people giving interviews on the, sharing their stories on the tour, and then also just, talking amongst each other. And so I wanted to thank the commissioner for that. And I think people have already, they haven't volunteered yet to do tours of their cities, right? Sounds like there's definitely a need to make sure that we 50 years from now don't call it hidden history anymore, that everybody knows about these facts and the impact they've had on our community. So I wanted to thank you. And I feel like we should clap. That's what I feel like.
Yeah.
So with that, we are moving into our rest of our scheduled program. And right now we have agenda item 8, which is the employment tables rulemaking. And we have with us Gordon Howard, who's the Community Services Division Manager. Let's start us off.
Chair Alova, Commission, thank you. Gordon Howard, the Community Services Division Manager for ELCD. This item 8 on your agenda this afternoon is amendment to our administrative rules in OAR 660038, which is the simplified urban growth boundary method. And those rules that we are amending today is the removal of 2 existing tables in those rules. First of all, the simplified urban growth boundary method was adopted by the Commission in 2015, and it requires the use for employment lands of tables provided by the Department of Employment of 8 or 10-year projections of future employment growth and also existing employment in those communities. Those tables need to be updated every year. And so we are before you today to remove the tables that you just adopted several months ago for 2020, and then putting in the tables, the latest tables, which are needed for 2021. It's a fairly simple process. Unless you have any questions about that, this should be a fairly simple matter for you to replace the old tables of the rule with the new tables through your action. Unless you have any other questions, that completes my report.
Commissioner, do you have any clarifying questions? Vice Chair,
Thank you, Chair. I just have a related question, and that is, have any local governments utilized the simplified EGB process since it has been adopted?
Chair Alova, Vice Chair, we like to answer that is no. There has not been any use of that. And in fact, we're hopeful that as part of our look at urban growth boundaries as part of the housing work, that we can hopefully, as part of that, update or modify the simplified UGB method to make it actually something that is useful and workable by Oregon's cities.
Great, thank you. And I fully support that. I was just curious about whether we, thank you.
I was more curious. I feel like I've done this before. And I was just curious why I'm just curious why we have to do voting. Why isn't it?
That's a very good question, Chair Holova. The reason is that the rules require the use of updated information. And it's not legally possible in an administrative rule to make a reference to a table or information that's changing over time. And so every time the table changes, we have to put the new table in the rule and adopt an amendment to the rule to do it. It's rather bureaucratic, but it's the way we have to do it, unfortunately.
Thank you.
The mischief is if we just adopted them prospectively, we'd be delegating our making authority to another entity. So that's why we get to go through the same process.
Chair, and add as well, the reason it feels so familiar is because we did do a school adoption in your April meeting, just in your last meeting. There was such a lag in getting data that the past adoption was very, very late, and staff in fact asked why don't we just skip over that and go straight to the new data that we know is coming. But I felt like we really wanted to adopt all of the data in series to the record so that we have it, we'll have it historically, knowing that the adoption in April this was coming right on its heels.
Thank you. That makes sense. So would any of the commissioners like to make a motion? And I think our motion will be on screen. But we have a pause. We're going to pause. Yeah. We're going to take a minute.
Having an audio issue.
Okay. So we're going to take a pause while we deal with audio. So, okay.
Should we take an actual pause? Okay. Okay, thank you. Thank you. So I think our audio, yes, I can hear it. It's gotten better. I wanted to see if anybody had a motion in this regard to update the tables.
I'll make the motion. I move to adopt amendments to OAR 660-038 and the amendments to table 3 and 4 that is referred in the rules as recommended by the department and explained in the staff report.
Second.
Can take the roll call, please. Jan?
Chair Halova,
Aye.
Vice Chair Lilac, Commissioner Warren,
Aye.
Commissioner Boyer,
Aye.
Commissioner Lasso,
Aye.
and Commissioner Sandoval has an excused absence.
And with that, the motion passes. So thank you, Gordon. So we're going to move on to agenda item number 9, which is the petition for enforcement against the city of Bend with Gordon Howard, our Community Services Division Manager, and Angie Brewer, Central Oregon Regional Representative. Gordon will start us off, and Vice Chair.
Thank you, Chair. I'm going to recuse myself from this agenda item. Mr. Kine, who has filed the petition against the city of Bend, is a frequent and regular applicant with Deschutes County, and we have a pending case now. And I just think it's in certainly my best interest and my employer's best interest if I recuse myself from this agenda item. So I will do so and leave the room and return. Thank you.
Thank you. Steve Shipsey.
Hi,
Mr.
thank you,
Shipsey.
Chair. And I'd also mention that we have a person joining us at the table here, and this is my colleague, Sarah Urch. And Sarah is working on this issue with the department as our lead on this. So I just wanted to introduce her. She's also from the Department of Justice.
Thank you. Just quickly, can you say your name again, please?
Thank you.
And Mr. Howard?
Yeah, thank you, Chair Lova, members of the commission, Gordon Howard again, of the Community Services Division Manager for DLCD. And with me for this item remotely is Angie Brewer, who is our regional representative for Central Oregon, coming to us from Bend. We're here today to speak on this item, which is a petition for enforcement against the city of Bend by Mr. Larry Kine. And at this point, I'm going to turn it over to Angie to give you the staff presentation on this matter.
Thank you, Gordon. Chair Holova and members of the commission, thank you for allowing me to join you from Bend today. I apologize for not being there in person. As Gordon shared, for the record, my name is Angie Brewer. I'm your Central Oregon Regional Representative. I serve 8 counties, including Deschutes County and the City of Bend. Today, I'm presenting a petition for enforcement recently filed against the City of Bend, and will briefly cover the commission's role, procedural steps, substantive matters of the petition, and staff's recommendation. Your packets include all of this, including the staff report and the recommendation, petition, notice of petition, and the city's response to the notice of petition. The city and petitioner will also have an opportunity today, oh, thank you for advancing the slide, to address the commission, but no other comments or evidence may be accepted at this specific hearing. The commission's role in this matter is to determine whether or not there is good cause to proceed to a contested case hearing, and ultimately, oh, not quite yet. Thank you. Thank you, Jan. The commission's role in this matter is to determine whether or not there is good cause to proceed to a contested case hearing, and ultimately to decide whether or not to pursue the issuance of an enforcement order. Just for general context, Oregon Revised Statute 197-319 through 335 and Oregon Administrative Rules Division 660 Division 45 provide an opportunity for citizen-initiated enforcement orders and the procedures that must follow. I appreciate this slide being on the screen. Just to pause here for a second. This is the order that will follow today for this hearing. So I'll give a brief presentation. It's very high level, capturing what's in your packets. It'll be followed by an opportunity for you all to ask us questions. And then there will be an opportunity for the petitioner and the city to provide brief presentations. And then another opportunity for the commission to ask questions of all of us, all the parties, followed by an opportunity to deliberate and then vote. Okay, next slide, please. So as you've read in your packets, a petition for an enforcement order was provided by attorney Christopher Kobach, representing BCL LLC. And for this process, Mr. Kobach is referred to as the petitioner and requester, or the individual who has filed the petition. The petition requests the commission ordered the City of Bend to bring its land use regulations, practices, and policies and decisions into compliance with state law and statewide planning goals related to ORS 197-307 sub 4. And the requester contends the City of Bend's review process for residential development creates unnecessary cost and delay. The petition is unique, and particularly unique because it cites both broad and specific concerns spanning from policies and practices to specific active land use applications currently under review by the city. Staff has summarized these concerns into 2 threshold questions and 6 specific concerns for your consideration. And so today the commission will need to determine whether these matters would benefit from the review of a hearings officer at a contested case hearing. Next slide, please. So the first threshold question is what types and categories of city actions fall under the authority of the commission to issue an enforcement order under ORS 197-320 sub 10. I apologize for how text heavy these slides are. As you read in your staff report, the petition cites concerns with added timelines of the city's building and engineering departments following the land use approval. The requester raises this to the commission to consider whether the time and cost requirements of these subsequent programs are in conflict with 197-307. And the second threshold question is whether this enforcement matter should be limited to the general review of programmatic compliance for the City of Bend, or if it should also include the review of the specific land use applications cited by the requester. Next slide, please. The applicant cites several specific concerns we've summarized in the staff report and are listed on the screen before you. But generally speaking, these include misaligned timelines and infrastructure requirements between city departments, potentially redundant review requirements, arbitrary fees, and extinguishing private easements prior to public dedication. So if the commission finds good cause to proceed today, additional research and analysis could occur for each of these concerns. Next slide, please. This slide illustrates the timeline to date. The timeline is rather condensed. We have 120 days from the date of the filing of the petition to issue our order. So because it was filed on the 21st, the hearing date for the contested case hearing must be set by August 5th, and the final order must be adopted by October 19th. The department intends to request the parties extend the final order adoption to coincide with our next regularly scheduled meeting, which would be November 2nd and 3rd. Next slide, please. So as a reminder, this step in the process is simply to determine whether the commission finds there is good cause to proceed. And in order to do that, the commission must find the petition contains substantial evidence of noncompliance and be able to cite the basis for that noncompliance. Next slide. The department recommends the commission find good cause to proceed to a contested case hearing because the requester has provided substantial evidence that the city's process timelines and fees may add substantial costs and delay to the development of housing. We'd also like to note for the commission that the allegations concern the provisions of needed housing in one of Oregon's fastest growing cities. And we believe that these are important issues for the state and commission, and a determination on them would help provide sound guidance to Oregon's local governments and other housing developers. Next slide. So because of these findings, the department's recommended motion shown on the screen is to find good cause and proceed with the assistance of a hearings officer. Next slide, please. These are alternative motions if the commission wished to consider them. The first being that they do not find good cause. The second being that they find good cause but would like to proceed without the assistance of a hearings officer. And the third being that they find good cause for some matters but not others and wish to specify. Next slide. If the commission finds good cause to proceed today and selects the motion recommended by staff, you would be authorizing Director Bateman to appoint a hearings officer, hold a contested case hearing, provide a recommendation to the commission, and the commission would hold a final hearing to determine whether or not an enforcement order was necessary and what that order contains. Next slide, please. This is a repeated slide of the recommended motion that we can come back to after deliberations if there's interest. Next slide. And this is also a repeated slide just to show us all where we're at and what's next. So following my presentation, this staff presentation, we're definitely available for questions, but then there are representatives from the petitioner and his client are available, I believe, in the room, and the city is participating by Zoom as well. So I guess I'll ask Gordon, do you have anything you'd like to contribute? Anything I missed in the staff presentation?
Chair Holova, no, not at this point. We're available for any questions you may have before we hear from the two parties.
Commissioners, do you have any questions related to the presentation? I think the only question I had that might get answered through the other presentations is there was a slide that talked about should this move forward something due to general compliance or review of specific land use issues. Do you mind going back to that slide?
Chair Holova, the question there is whether you want to direct the hearing. We would recommend you direct the hearings officer to make that determination, whether the hearings officer would stick to issues generally with Ben's processes for processing of residential development applications, or whether the hearings officer would delve into the specifics. Mr. Kine has and his attorney have alleged in their petition regarding specific actions regarding specific applications of the city that where Mr. Kine was the applicant.
Something that the hearings officer would.
That is something that the hearings officer would determine. Yeah.
So I think with no other questions, we can move to the next part of the agenda, which is the petitioner presentation.
Thank you. Can everybody hear me? Chair Holova, members of the commission, my name is Chris Kobach, and with me is Larry Kine, my client, and who I petitioned on behalf of. We appreciate your time today, having us over from Bend, and we appreciate the attention your staff particularly has given to this issue, and the attention that I'm sure you're giving to it as well. So for a brief introduction, Mr. Kine is a developer, a lot of residential development in Central Oregon, and a lot of affordable development. Recently, one of the projects you're going to hear about today was awarded $10 million by the state to build affordable housing in Bend. And it's a crisis because we don't have enough housing for the people that need to work in Bend to provide the services that Bend needs. And we're trying to cure that. And so we're here to petition to the commission to enforce some stuff against the city that will help us do that. The staff did a wonderful job with the law and the jurisdiction, and I'm not going to go over that again because we don't have a lot of time. And I think I want to focus on putting some factual context behind staff's wonderful presentation of the law. So we believe that the state is authorized, this commission is authorized to take action against the city because it has land use decisions and actions implementing them that are not consistent with the comprehensive plan and are in violation of 197-307, particularly that section that states the city can't apply a standard, a condition, or a procedure that has the effect of discouraging housing through unreasonable delay in cost. And to put that in a little context, Bend's comprehensive plan, section 5.7, specifically deals with providing housing. The Bend's comprehensive plan policy says Bend shall remove barriers from housing, and it should make different housing available at affordable levels. And that's their comp plan. But in practice, what we're seeing is that Bend is their practices, their policies, their conditions, their procedures, implementing land use decisions are actually creating huge barriers. And I want to talk about really what that means. So Bend has a development standard that applies in every land use decision. It says you have 2 years to implement this approval. And that applies for multifamily housing because you have to do site plan review in every one. And for a residential single lot development, you have to get a subdivision approval. And that is a 2-year expiration provision. What's really critical to understand is what the city also puts in its decisions. The city says to a developer, you must, within those 2 years, you must improve these public improvements on your dollar. And then you have to get building permits in order to vest in that approval. And that's where we have what the staff referred to as misalignment. I've heard it referred to as a major disconnect. We call it just a barrier to development, to housing, because what we've experienced in some of the examples we've given you is that it takes staff, the engineering staff for these public improvements. You know, the statute 97097 states that if the city's going to make the developer build the public improvements, our engineer gets to design them and inspect them. The statute gives the city the option to review the plans, but they don't have to. But Bend does. And they start that review after the final land use decision. So that comes down and the developers pays their engineer to develop all of the infrastructure plans. And that can be done in about 3 to 4 weeks, the whole creation. And then it goes to the city of Bend, and we've waited 327 days in one project to get review done. We waited 7 months on Daily Estates, our affordable one, before they even began review. It took 13 months to get that review done for that infrastructure. So once that infrastructure is reviewed, then construction can start. And so then the developer has to build all of the public improvements. The city has to inspect it. Again, they don't have to, they choose to inspect it. The developer has to pay for all of that, all of the review fees that's on top of the building permits. And then they have to get, this is another thing, the code states that to vest in your approval within 2 years, you have to initiate the use. Now, Bend's practice or policy is to interpret that to say you have to get building permits. So even though we've spent hundreds of thousands of dollars on the infrastructure, that's not enough to initiate the use. Bend requires you to pull all of the permits. So on Daily Estates, the affordable one, we have 19 units in 10 individual structures. To vest in that approval, you have to go through that whole 13-month process to get the engineering reviewed. You have to build it. You have to go through the building permit review process, and then you have to pull 19 permits. Those permits in that cost $877,000 for all 19. We asked, could we pull one at a time? You can't do that because it's multifamily. Even though they're individual structures, they can be approved, they can be built, inspected, approved, and lived in independently. You have to buy them. There's a 180-day expiration on those building permits. Now, if you were a big major developer, national developer, you might be able to build 19 at once. They don't do affordable housing. The local people like Mr. Kine, they do affordable housing. They can't build 19 at once. So before those permits they'll expire before we can build them. And guess what? Then you go back and you start the whole process for the building permit review again, a new fee, more review. Those are the barriers we're seeing in the affordable housing context that we think that needs to be addressed, because it's not about reviewing land use decisions. We've made it through the land use process already. This is about the disconnect that after we get that final approval, we have to meet these serious conditions, and the city's review policies and practices and procedures will not allow us to do that. The building permit review is also another problem, because once you get through the engineering, which is the major delay, for example, on Daly Estates, we had 19 identical units in 10 buildings. They were identical buildings. They got sent out to different reviewers. So we're getting plans with comments that were inconsistent. Instead of sending it to one person to review, it goes to different people, and we get inconsistent marks that we have to address. That was one of the problems with the building permit review. The other thing is we couldn't start that until the sewer was in, the public improvements in. So when the city in their response says, well, we do concurrent review, that isn't absolutely true. In our experiences, they don't always do concurrent review of the engineering and the building permits, because there's cases like ours where they say, no, we're not going to do that because we want to see that engineering done. We want to see that improvement in so we can see how the building lines up with it. We don't think that's necessary. Another issue we encountered with the building permit review is that when the city says, well, we're making progress on our first review, and that's in their response, our first review time has gone down. Well, that's a statistic that you can just play with, because what we've experienced is maybe the first review comes back a little faster. But for example, on batch review, it's one of our exhibits. We got the first comments back after about 8 months. They didn't review anything because they said we included something on our plans that the hearings officer specifically allowed, but the staff didn't like. So they didn't really review anything. And in the building permit context, what we're getting back are reviews that have some comments. And then our engineers and architects respond to them. And we get another set of comments back with 20 more new things. They could have been on the first review. So then after 2 or 3 of those, their statistic on the first review looks good. It looks better. But their overall statistic after the second and third wave of these new comments makes their statistic look bad. And they didn't give you that. But that's what we're seeing on the ground. You know how much time I have? I have 1 minute. So what I want to talk about is dedication finally for about 30 seconds. So historically, the city has allowed dedication subject to easements. And in the development right next to Batch Review, they did that on a private road access. Then they changed their code to say, now you have to remove all easements and encumbrances, private easements, encumbrances, before you dedicate that road. But they're requiring us to dedicate that road in a specific location. There's an easement there. So what that means is the people who are neighbors, who are actually adamant opponents of housing in that area, we have to go to them and say, please remove that private easement. That's a standard that makes housing impossible in some contexts, because we do not control those easements. And the city's response is, well, come to us under our discretionary review and we'll think about it. Well, the person we would go to, their engineer, opposed our development. So that's not really a good result. And also, if we have to subject ourselves to a discretionary process, they're really forcing us to get rid of our rights under 197307 to have clear and objective standards. So we think that's another policy that is the epitome of discouragement of housing, because it takes it out of our control. We can't get that easement released. And so to sum up, we think there's substantial evidence. We agree with staff that there are these violations and there are inconsistencies with the comprehensive plan and the land use decision implementation. And we think the best thing to do that would serve the commission best and the citizens of Bend is if we had a good cause hearing, went to a hearings officer, fully developed the record, had it come back to you on a recommendation from a hearings officer so that you'll have not only a hearings officer, another third party's view of this issue, but you will have it with a fully developed evidentiary record, something we just can't do in 10 minutes, as much as we'd like to. We'd like to spend here all day here telling you about these issues so that we can move this forward, but we just don't have that time. And we understand that. Thank you very much for your time.
Thank you for your presentation. I think we can ask questions. Yeah. Commissioners? Or do we? Sorry, I didn't have the slide up. That's guiding me, Eric. Or we're gonna wait. Okay. City presentation is next.
Good afternoon, everyone, commission staff. Thanks for giving us the opportunity today. I am Ian Lighthizer. I'm a lawyer at the City of Bend City Attorney's Office. I'm going to take a couple of minutes and then pass the virtual microphone to, I think, Russ Grayson and then Colin Stevens. It was notable to me both in Mr. Kobach's presentation and in the first line in the introduction section in the June 21st petition that he said there's no question Oregon has an affordable housing crisis. City doesn't disagree, but we do think we need to point out to the commission that Mr. Kobach's client didn't always see things that way. It wasn't that long ago in 2015 and 16 when the city was attempting to facilitate affordable housing on property it owned, that Mr. Kine vehemently opposed that rezone and comp plan change process because he was developing other property in the area and didn't want affordable housing near him. In that proceeding, Mr. Kine referred to the city making an undocumented claim that there is an affordable housing need. And he said the city merely stating there is an affordable housing need does not make it fact. Mr. Kine himself created unreasonable or unnecessary cost and delay for a different developer who was attempting to develop that property because Mr. Kine's position at the time, as he told the Bend Bulletin in February of 2016, was that he was really irritated because in his view, the city can just do whatever they want and don't have to follow the same rules as anyone else. Mr. Kine took that to LUBA twice, ultimately lost. The city was able to facilitate that project, which eventually became 96 units of affordable housing over Mr. Kine's objections. But since then, his tune has changed. His tune has changed to the point where he has used the policy shift at the state and local level as a cudgel to create friction with the city to get what he wants. Now, we understand there is going to be tension in the development process. There can be, but a handful of cases of friction on particular projects does not necessarily equate to good cause to proceed to a contested case hearing. In order to find good cause, the commission needs to determine that there's a pattern or practice of decision-making that violates an acknowledged comprehensive plan or land use regulation. We appreciate the work that staff has done to try to break this down into a couple of threshold questions, because I think that the first one helps answer that question. I don't want to put words in the mouth of staff or read too much into the report, but that threshold question number one about what types and categories, of city actions fall under the commission's authority is instructive. And I would request that you give that some serious consideration today. And that's in part because much of what Mr. Kine is alleging and much of what you heard from Mr. Kobach about review timelines are for infrastructure permits, and those aren't necessarily land use regulations that would potentially be subject to an enforcement order. And in our view, that means that if the commission does find there's good cause to proceed to a contested case hearing, we think that concerns 1 and 2, which staff have identified centered around review timelines, really should fall away as not something that the commission has the ability or really an interest in delving into. I'm going to go through the other issues really quickly before I turn it over. Staff has identified the concern with engineering fees and actual costs. I will repeat what Mr. Stevens said in his June 20th letter to Mr. Kind and Mr. Kobach. The city has since amended its fee resolution to account for actual costs for engineering review. To the extent that was an issue, it shouldn't be anymore. The city has also indicated a willingness to work with applicant on what I'll call concern 5 about condominium plat review, and the same on concern 6 with stormwater standards. The city is undergoing an update of its stormwater management plan, and our standards for underground injection controls will be part of that review. To me, that really leaves concern 3, which I would frame as whether an applicant can require the city to accept encumbered right away, as something where I don't really think we can say there's the potential for a meeting of the minds. But before I turn it over to Russ Grayson, I will say that to clarify, that particular standard has never been applied to Mr. Kind and has not been applied to any of his either existing or pending applications. So we don't really see how the commission can find that there's good cause or substantial evidence of non-compliance regarding that issue when it really hasn't been applied to any of Mr. Kind's projects. I've gone well over the 2 minutes I intended to take, so I'm going to turn it over to, I think, Russ Grayson next.
Good afternoon, Commission. My name is Russ Grayson. I'm the Chief Operations Officer for the city. Previously, I was a Community Development Director, and previous to that, I was a City Engineer. So one, thank you for taking the time. As Ian alluded to, we do take these issues seriously. This is not just a departmental level question. This is a citywide level. We do have common vision with the petitioner in terms of getting more housing on the ground. That's evidenced by several council goals and some information that Colin will go over in terms of what we've been trying to do to comply with the recent rules from the state, as well as the city policy direction that we're receiving from council. Just as an example, if we do go to a hearing, we'll provide additional information around this, but around review timelines. This is in reference to the project that is in the exhibit 1 of the petitioner's letter. Just to give an overview of the timeline of what happened, they filed their original application in August of 2022. They didn't pay the fees completely until December. The application wasn't deemed complete after a review, got the fees and started the review until January. The early January, the first review was completed by the end of January with 6 pages of comments, over 100 comments, which is abnormal for our review cycles. That was returned to them at the end of January. They resubmitted back to us, and we started our second review in the middle of May. Got those comments turned around by the end of May. There are still 5 pages of comments. I would ask the commission, if you are curious about what some of those comments are, please look at that letter as exhibit 1. Most of those are very simple issues that we are not receiving fully designed plans when we review them, and they do not meet our standards. But when you read the comments, there's a lot of information that is missing on those plans. We return that, and we're still waiting for them to resubmit 2 months later so that we can do our third review. In addition, we talked about if they're anxious to get building going, there are 19 building permits that have been sitting at our front counter waiting for pickup for several months that are ready to issue upon payment. The city is still willing to work with the applicant, and we are to resolve these issues and get the projects going, because we want to get housing on the ground just as much as the applicant does. I was really quick with that, and we'll be able to provide more information if this goes to hearing, but I would like to turn this over to Colin for the final couple minutes to kind of give an overview of what we've been doing to work with all the new state rules, as well as the council policy direction, and as well as other things that we've been doing internally to improve our service levels to our customers. So Colin.
Thanks a lot, Russ. Colin Stevens, Community and Economic Development Director. So the City of Bend has a track record of fostering needed housing. We've been working with the legislature. We've been working with the department staff. We've been working with the commission on this. So I have some examples of some higher level policy initiatives that we put into place. We did some ADU amendments to remove conditional use permits, sidewalk requirements, increased unit size from 600 to 800 square feet, increased building heights, and this was in 3 separate code amendments from 2016 to 2021, increased lot coverage and lot depth in residential zones, added incentives that allow further reductions for affordable housing in September 2018. We implemented the House Bill 2306 early platting program, and we created 2 additional locally established early pathways for platting. We did that in 2019. Then Central District amendments allow standalone residential uses, including townhomes, live work units, ADUs, and multifamily dwellings in commercial zones. That was in 2020. We created micro units, shared courts, small dwelling units. Most of these are locally created new housing types. We did that in October of 2020. We implemented House Bill 3450, working with department staff to create up to 40 acres of multifamily development in commercial zones. That was in 2020. We actually have multifamily under construction under that program right now. We did House Bill 2001 for middle housing. We eliminated maximum density for multi-unit affordable housing, eliminated residential compatibility standards and increased building heights in other residential zones. And that was in October of 2021. We were one of the first large cities to implement HB 2001. We got Senate Bill 458, middle housing land divisions on the books now. And we eliminated parking minimums in February of 2023 in advance of the requirements under CFAC. So improving permit turnaround times has been a city council goal for the last several biennial cycles. In the past year, the city has engaged with local design professionals to develop programs to improve engineering and building permit processing. These initiatives were put into place for building and engineering at the beginning of 2023 with measurable results. Mr. Kynes, engineer, participated in with staff in this process. City established goals for building permit review timelines and has advanced permitting software in place that allows staff to compile and establish detailed information on these timelines. This data is available to the public on the CEDD webpage.
And I was going to say, Colin, you're, I think, at your time. So if you could.
My time. Okay.
Yep.
Just in closing, I'd like to say that the city has a pattern and practice of encouraging and fostering the development of needed housing. Several examples of longer than usual permit review times related to one developer who challenges every direction from staff and does not respond to review comments in a timely manner does not change this fact. Thank you.
Thank you. Okay, so I think we're moving on to LCDC Commission questions. And I'm believing those questions can go to any of the folks that have presented to us. I'm looking for somebody to give me the nod. Thank you. Look that way, not that way. Commissioners. Commissioner Lazo.
Thank you, Chair Oliva. I'm a couple questions. I think maybe Gordon, you can help clarify these for me. In looking at the materials, it looks like there's some question about whether or not. So I guess maybe I should back up to the role here is for us to find whether or not there's substantial evidence of non-compliance, right? So the first question will be: are we looking at whether or not there's substantial non-compliance on the question of whether or not these procedures are clear and objective standards, or whether or not they are creating an unreasonable delay, or is there it looks like there's a kind of a combination of both in the concerns that are raised.
Chair Holova, Commissioner Lazo, I would characterize the allegations as related to the second half of that clear and objective standard, which is not as well known, which is clear and objective standards that do not cause unreasonable cost and delay. And clearly in the staff's position point, looking at this, the allegations are that these are not necessarily that there wasn't much of an allegation that they're not clear and objective. The allegation is that they cause unreasonable cost and delay. And that would be the basis on which the decision on whether to issue an enforcement order would occur.
So can that piece stand alone then? I mean, I guess if they're, so they can be clear and objective, but if they're causing an unreasonable delay, then that can be substantial evidence that it's a non-compliance with that.
Chair Holova, Commissioner Lazo, the statutory provision says clear and objective standards that do not cause additional cost and delay. So if they can be in violation either if they're not clear and objective, or if they are clear and objective, but they cause unreasonable cost and delay.
If I could, the second part of the question is, it looks like there's some question about sort of jurisdiction between whether or not these questions are for us or for LUBA.
Chair Holova, Commissioner Lazo, the issue that we are concerned about is that if you remember back in April, we had the Eugene situation where your commission found that we didn't have authority to issue something because these weren't land use decisions. And that was a proposal was being brought under a different provision of the enforcement rule authority the commission has, subsection 6, which was pattern and practice. I think the city of Bend mentioned that. This actually is being brought under a different section of the statute, subsection 10, which is a specific thing that the legislature added in 2015, saying the commission had enforcement authority for local governments not complying with the clear and objective standards that don't cause unreasonable cost and delay.
Yeah.
And so that's never been brought before as to whether that also deals only with land use decisions, which most of these aren't, or whether that applies to the entire city process. And that's something that has never been adjudicated by LUBA. And therefore, this would be a kind of a novel area of law, whether that provision allows for an enforcement order to be applied. I think the question for LUBA was whether this is an individual case that the applicant should have gone to LUBA instead. And really, that's actually not a criteria for consideration of an enforcement order, whether LUBA could handle it better. It's just whether it's in the commission's authority to do it or not.
Okay, great. Thank you.
This is a very different case. So based on everything that you said, could you reiterate, I know you've said it many times, why you feel that we are the right body to address this, kind of going along to the comments that they're very specific, building code, kind of planning division. Well, it depends on what Ben does, but they're about review timelines. And so, yeah.
Chair Holova, I think that was the threshold question. One of the threshold questions is whether the commission should mainly be concerned about issues with Ben's processes that are brought up by the petitioner, or whether the commission should delve into the details of the petitioner's travails, if you will, with the city of Bend and their processing. And that's something that we'd like to have the hearings officer return with. I would say that in a previous case from 2016 involving the city of Corvallis, the hearings officer at that point did not delve into the details of the petitioners in that case, or requester, the terminology, and stuck to the larger issues of flaws in the city's process, and the enforcement order went that way. However, we would be asking the hearings officer to come back and make a recommendation, either to make a threshold determination, whether to get into those details or whether to stick to bigger issues, such as whether there's a general misalignment in the city's building or timelines to get to a final plat. The questions that we put forward in the staff analysis of the petition.
One of the reasons I asked that is because the city was talking about the first one with the timelines of planning. They didn't feel that fell within our world, let's say. And then, they just went through different points. So with this one, we already resolved that issue, and that one, so that's why I was trying to get to that.
Commissioner or Chair Holova, there is a lot of factual dispute in this case, certainly. And at this point, instead of trying to figure it out as part of the good cause hearing, we recommend that's one of the reasons to take this to the hearings officer, because there are a lot of questions of both fact and law involved in this case. And it's our recommendation that the hearings officer, through a contested case hearing, is the best mechanism to resolve all that and come back with something that makes sense for the commission to consider whether to issue an enforcement order, and if so, what the conditions of that enforcement order would involve.
Commissioners, any other questions? Commissioner Boyer.
Sorry, I got something in my throat. So the city of Bend, went through all our concerns, and the one that they were highlighting that should maybe be looked at is concern number 3 about extinguishing private easement prior to public dedication. And in the explanation, it discusses that the city adopted this standard. So I'm curious, was it adopted during the petitioner's process, or when was that adopted?
Yeah. Chair Alova, Commissioner Boyer, I'd have to defer to both the city and the petitioner on the details of when that occurred.
Process of
Yeah.
of this particular application. Can anybody answer that?
We have Ian from the city.
Thanks. Yeah, I can answer that at least generally by saying that was an amendment to the city's development code, and that amendment was proposed and adopted by the council prior to this enforcement, or the potential enforcement issue was presented to the city. So it was not in response to this. I think it's also worth saying, if I may, that there has been no attempt by the city to apply this to any of the petitioner or requesters pending developments. There's a pretty fundamental goalpost issue that I think we're on the same page with Mr. Kobach and Mr. Kine on. So this particular provision is certainly not impeding any of the projects or applications that Mr. Kine has raised in his enforcement petition. I do have some disagreements with the way Mr. Kobach framed the city's practice historically of how we review and accept right-of-way dedications. He did note one particular example of the city accepting encumbered right-of-way, but one instance does not a pattern or practice make. And I think my point on that issue, which I've called concern 3 as identified by staff, is that's one that really probably hasn't been resolved yet. I think the parties disagree on what it means. I will note that this was a code amendment that went through the normal legislative process where the city amended its development code. Mr. Kine was actually at the hearing and testified at the public hearing before the city council. He chose not to appeal that to LUBA, but he's coming to the commission asking that the commission do something about it when the provision hasn't even been applied to any of Mr. Kine's projects.
Could I please respond to that?
Yes, Chris Kobach.
Thank you. First of all, it is true that in the tentative, there's 2 phases for the subdivision, and in the tentative plan section, we were in before that code amendment took effect. So under the goalpost rule, Mr. Lighthizer is correct. It was not applied directly to any of our projects. But just recently, last week, a project out on Acapella, who also fell in under the goalpost rule, submitted for a final plat. It's a separate process. And the city's applying that new provision to the final plat. So I think it's even worse, because think about it, we could develop the whole infrastructure, get everything ready to go, and then go to the final plat, and the city will say, well, that's a separate application. You don't qualify under the goalpost. You've got to remove that easement. And the easement that we're talking about, and the reason I cited it as precedent, it's the same easement that the city accepted dedication for on the residential subdivision immediately adjacent to us. The easement runs through that development and through ours. And so my point was, if you accepted the dedication subject to the same easement in that development right next door, why would you not want to do it here? And there's also a disconnect, because I think the city council agrees that easement should not uphold residential development. But I think it's staff pushing for this. And that's another disconnect where I think developing these issues at a hearing will help everybody get to the bottom of these issues and determine what needs to happen to effectively provide housing. Thank you.
Commissioner Boyer.
So let's see, in Angie's presentation, there were three options. Do not proceed, proceed with a hearing officer, and proceed without a hearing officer. Is that, did I hear that right, Angie?
Chair Holova, Commissioner Boyer, the slide, I believe, I can read it to you on my screen, but it has 3 alternatives. There's the recommended motion, that it recommends you pursue a contested case hearing with the support of a hearings officer. The first alternative was to find no good cause. The second alternative was to find good cause but pursue the contested case hearing without the assistance of a hearings officer. And the third was to pursue a contested case hearing with the help of a hearings officer, but only pursuing some of the cited concerns, not all of them, and taking the time to be specific about what those would include. And I suppose there are other combinations that could exist if the commission chose to deliberate on that.
So we can send it to hearings officer, or we could deliberate on it ourselves.
Just want clarity. Thank you.
More out of curiosity, or trying to understand, Gordon, would a hearings officer have the ability to decide, oh, this question about this private easement question, like, oh, that actually, if they found this to be the case, that doesn't apply to this project. So I'm just going to ignore that number 3, but I'm going to pay attention to the other ones. That the hearings officer can do that decision-making if they want.
Chair Holova, you're correct. The hearings officer, that could be there's numerous theoretical outcomes that could occur on all these issues through the process. And that gets to the threshold question, is whether you're looking at the city's overall processes or looking at the specifics of the processes as they relate to this particular applicant. And that's something the hearings officer would need to figure out. This would be a fairly complex matter to go through in a contested case hearing. By the way, the option that doesn't have a hearings officer has your commission acting as the hearings officer, which would be quite a lot of work.
And then, just as from my understanding, in Bend, does the city do the plat type of subdivision work, or is it a county? Because I know it's different here, at least, what the city does versus what the county does with regard to building permits versus subdivision.
Chair Holova, generally in Oregon, plats are approved by the city, and then they are generally recorded with the county. But the county's action in that case, the county surveyor does things, but that's, I believe, generally a purely administrative matter that the county's involvement.
Thank you. Commissioner Warren.
Gordon, I'm curious, do we have a definition of what unreasonable cost or delay means?
Chair Holova, Commissioner Warren, that's one of the reasons why this is a very untested area of law, is that the question of unreasonable cost and delay is not well developed in case law. It had some very minor aspects in cases involving, I believe, in Eugene and Ashland 20 years ago, but it's generally not been defined very well in state law, and therefore the commission, this raises a interesting area of law, and it would be, I think, of some benefit going forward for the commission to look at this issue and make a determination.
Any other further questions? Discussion? Commissioner Lazo.
Gordon, I guess given your statement, the inverse of that is, if there was a finding from the hearings officer that these aren't unreasonable costs and delays, would that be a concern for us? I guess that might be too much judgment right now.
Chair Holova, Commissioner Lazo, that would be depending upon your review of the evidence, because as the final decision maker on an enforcement order, you may not agree. If the hearings officer comes to a conclusion you don't agree with, you don't have to you could come to a different conclusion. That the hearings officer is providing a recommendation to you, not a final decision.
Oh, okay.
Because these topics are a little too close to home, I'm trying to make sure to separate personal thoughts from from reasonable thoughts, if that makes sense. Are we allowed to call on one of the
think you're at the point where you can ask them questions, but it's probably not appropriate for them to be posing questions to you.
Sorry about that. Um, it's from my perspective, it's like I understand each one of these points from like the actual development point of view, given my experience. And so that's why I just trying to separate like, okay, there's the facts and the hearings officer might want to get into these facts or might say, this is not the time to get in those facts, but just overall, this kind of cost and delay. And I believe the unreasonable cost of delay has been on the books for a long time, but not in the way that it was put in 2015 can you maybe expound on that? Because I know I believe I know that the concept of unreasonable cost and delay prior to that 2015.
Chair Hulova, the language and reasonable cost delay, I believe, has been in the statute since when it was first adopted back in the early 1980s. It became a matter that the commission could consider as an enforcement order in 2015. And there isn't, even though the language has been on the books since the early 80s, there isn't a lot of case law. The case law has been concentrating on what clear and objective means, not the second half of that, which is the unreasonable cost and delay part.
I don't know if anybody else wants to talk before me.
No, I agree with Gordon saying this is a factual dispute. That was my takeaway after reading all of this. And I read it all. So that's where I'm
Leaning toward
hearings officer.
Similar leanings by folks.
I agree.
Yeah.
Questions answered.
Yeah. We're all saying we'll get a lot of questions answered through a hearings officer. Because I think there's different layers to this, right? It's like the factual dispute layer. Then is this hearings officer going to want to take each one of these points with the facts and talk about them, or just see this as a whole, say cumulatively, these have cost unreasonable cost and delay. And then there's Commissioner Lazo's. And then if you say no or yes, right, that means something, but we don't know what that means until somebody looks at the details and says what that is. But it will set an understanding of this topic that has never been set. We will set an understanding of this topic that has never been set. How about that? So I think with that, I also agree that we agree with staff and the department that this requires further study by the hearings officer. So I would like to recommend a motion. Which would be the recommended motion if Jan, if you can put up I
have it in the annotated.
Or Angie, put up the recommended
I have it, Chair.
motion. Commissioner Lazo.
Yeah. I move that the commission find there is good cause under ORS 197.320 sub 10 to proceed to a contested case hearing regarding requester's petition alleging the city is not in compliance with ORS 197.307 for the matters identified in the department's staff report, and direct the director to issue an order describing the reasons for this decision, direct the department to appoint a hearings officer to conduct a contested case hearing, and direct the hearings officer to schedule and hold a contested case hearing.
Anyone to second?
I second.
Jan, if you could do the roll call.
Chair Halova,
Aye.
Vice Chair Lilac. Oh, is recused. Commissioner Warren,
Aye.
Commissioner Boyer,
Aye.
Commissioner Lazo,
Aye.
and Commissioner Sandoval has an excused absence.
And with that, the motion passes.
Thank you.
Thank you for both testimonies. And presentations. Okay, so we're going to take a 15-minute break, and when we return, we'll have agenda item number 10, Farm and Forest Program Update with Hillary Foote, who is the Farm and Forest Specialist. And so we will come back at, sorry, I can't really tell what the times they're saying, 3:45. See you soon.
Oh my gosh.
Welcome back. Up next, we have agenda item 10, which is the Farm and Forest Program update with, oh, why do I say that? Welcome back. Up next, we have the agenda item number 10, Farm and Forest Program update with Hillary Foote, Farm and Forest Specialist. Welcome.
All right, thank you very much, Chair Halova, Vice Chair Lilac, and Commissioners. So I am Hillary Foote, and I am the Farm and Forest Land Use Specialist for the Department of Land Conservation and Development. And today I'm going to be talking about a work plan that the department intends to engage in over the next 6 months to scope out a proposal for a multi-year project to implement improvements to the farm and forest programs. And the intent is that over the next 6 months, we'll be engaged in a scoping phase. And then in January, staff intends to bring a report to the commission, documenting that scoping process and making recommendations for future action. So in January, we hope to have a robust discussion with the commission about those proposed actions and seek direction. So the commission might remember that at our meeting in last January, we reviewed the biennial farm and forest report for the legislature. And in addition to reviewing trends in conversion and development on lands that are protected under exclusive farm use zoning and forest zoning, that report also highlighted some key and well-known areas in the structure of the farm and forest program that could really use some clarification and improvement. And as I recall, at that time, it was Commissioner Boyer who asked the department what we intended to do to address those known issues. And in response, we pointed to an area in the draft strategic plan that is a carryover in part from the original, the current strategic plan. And we're very excited to talk a little bit more about that tomorrow. But there is one element in the strategic plan that calls for the department to work with stakeholders and our sister agencies to engage in a process to address lack of consistency, lack of clarity, and technical errors that exist within the farm and forest land use programs. All right, so what I'm talking about today is the first step in that effort. That is the scoping phase. So I'm going to go ahead and provide a very quick refresher on the background of the Goal 3 and the Goal 4 programs. And then I'm going to talk about that first phase, the scoping process that we're going to be doing over the next 6 months. All right. All right, so a reminder on the background of these programs. And I'm going to talk a little bit more about Goal 3, the Agricultural Lands Program, than Goal 4, in large part because Goal 3 has a richer history. And Goal 4 ultimately ended up being modeled in large part after the Goal 3 program. So when we're talking about both the farm program and the forest program, it is really critical to remember that these are conservation programs. These are programs that are intended to preserve agricultural land and timberland as working lands.
Sorry to interrupt you. Can we make the screen with the slide bigger? Thank you.
And it's also important to note that the Goal 3 program actually, exclusive farm use zoning actually predated the land use planning program by over a decade. You know, it was originally standardized across the state, exclusive farm use zoning, as part of an incentive tax program in 1963. So it was a policy response to address a rapid conversion of prime farmlands throughout the Willamette Valley to urban uses. And it's something that was happening actually across the United States at that time. So when Senate Bill 100 and its partner bill, Senate Bill 101, the Agricultural Lands Bill, were enacted in 1973, they did a couple of very important things. So inventory of all land that met the state's definition of agricultural lands and rule based primarily on soils was required to be inventoried as agricultural lands. Forest lands were also required to be inventoried. And that exclusive farm use zoning, that protective zoning that limits the developing of uses on those lands became mandatory. And when that zoning became mandatory, the associated tax program became part of a suite of compensatory benefits that were conferred on those landowners in exchange for that really restrictive zoning that was meant to preserve those in working land use. Another really important thing that happened when Chapter 215, the exclusive farm use statutes, were overhauled was that the legislature established a statutory policy highlighting the importance of the preservation of agricultural lands to the state. So that is a policy that's codified in statute at 215-243. And it was enacted before Goal 3 was. Goal 3 actually references that statutory policy. And I'm highlighting this because the policies that underpin the Goal 3 program, and there's actually a number of other policies that are codified in statute in 215 as well. But I'm highlighting that because the policies that underpin the Goal 3 program have been established for quite some time. And when I'm talking about, updating the farm and forest programming, I'm not talking about updating those core policies, those foundational policies that have been in place in the state for several decades. What I'm really talking about is that legal regulatory structure that implements those policies, the nitty gritty day to day, right? So I'll talk about that really quickly. Uses that are allowed in exclusive farm use zones are established by the legislature. Only those uses that are listed in statute can be developed on lands that have been protected under exclusive farm use zoning. And those uses are divided into two buckets. The first bucket are uses that are allowed outright, uses that the legislature determined to be compatible with agricultural operations and forest operations. And then there's a second bucket of the uses that the legislature said, maybe these are compatible, maybe they aren't. It depends on the individual circumstances. And so for these type 2 uses, a county needs to review those through a public process, and they need to find that those uses will not significantly impact farm and forest operations in the surrounding area or the cost of those operations. It's called the Farm Impacts Test, and it's sometimes just referred to as 215-296. The forest zone has a similar structure. There are buckets of uses. There are the allowed outright uses, and there are uses that require findings against the Forest Impacts Test. The difference is that that use list was established by the commission through rule. Okay. And so that seems pretty straightforward when I talk about it. But that structure has evolved significantly over the past 50 years. Yeah. When the use list was originally created, there were 6 uses, 5 of them non-farm uses. Right. There's over 60 now. And changes to the program have been implemented, through action of the legislature, through rule adoptions by the commission, and really importantly, also by the courts. So development of non-farm and non-forest, non-resource uses on those lands that have been protected by the state as working lands often tend to be controversial. And so many of those non-farm uses have resulted in appeals to the Land Use Board of Appeals, the Court of Appeals, and the Supreme Court. And there exists a very large body of case law and legal standards that should be applied to these types of reviews. Some of them are codified in our rules, and most actually are not. And so the problem with this is it leads to very uneven application of those standards through review processes conducted by different counties, depending on the level of resources that counties have. So codification of case law is just one of those issues. And there are a number of really important decisions by the court that really, the whole program would benefit from having codified in rule, right? To have standardized application across the state. But there are a number of other issues, from lack of clarity in definitions that have resulted to certain types of uses being repeatedly appealed and going to the courts, to the sheer volume of certain non-farm uses that are routinely approved on protected exclusive farm use lands, right? And DLCD staff, the farm and forest specialists, have been keeping track of these issues for almost 15 years now. When I started with the department 3 years ago, I inherited a very long list of issues, and I have been adding to it over the 3 years that I've been here, as I've been contacted by counties looking for guidance, as the courts have continued to issue responses through the appeal process. So what are we going to do with this big, long list of issues, known issues with the program? So what staff is intending to do is to start with that list that the department has maintained over the years and take it to a technical working group who will be asked to review that list and flesh it out, identify items that are missing, or if there are items on that list that maybe shouldn't be there. To prioritize that list, like if we addressed this particular issue, would that have a really big impact on consistent application through the state, or truly implementing the agricultural policies? And then we are going to also have a conversation about ways that those issues could be addressed. So that is the intention, to convene that work group. I'll talk about the schedule in a minute. And ultimately, that conversation with the work group be rolled up into a scoping summary report that will be prepared by staff with our recommendations for future action, and again, brought to the commission in January. All right. We are intending to convene a group of 10 to 15 people who have a working familiarity with the program, who are familiar with the legal structure of the program, and engage in conversation about things like, what is the best way to capture the court standards in, for example, Stop the Dump versus Yamhill, on how counties should prepare findings against the farm impacts test, right? The work group will be appointed by the director. We have just this week started reaching out to members of that working group. Right now, was there anything else I wanted to say that? No.
Commissioner Boyer.
Can you go back to the list, please?
Mm-hmm.
So are you asking, of course, I look at the Department of Agriculture. Are you going to ask the Department of Agriculture to bring a name or a few names forward, and then you will pick, and then I look at the Board of Ag. Is the Board of Ag going to recommend somebody? I'm trying to figure out how you will.
We'll be extending official invitations to members. Mm-hmm.
Have a recommendation. Yes.
And I was going to ask a question since we're talking about it. I just want to make sure we keep in mind our equity goals with regard to, kind of who has been left out of this process in the past, and just to have a lens toward thinking about that for the future.
Yes, thank you, Chair Holova. And that's certainly something that we have thought about in making recommendations for this list. And I also want to assure the commission that there is going to be a public process around this over the next 6 months. And that's kind of a little bit what I wanted to get to on the next slide.
And sorry, I just wanted to clarify. There's the folks that are picked for the individual roles, but I'm also, because this is not my area, I'm also like, are there is there an actually different categories that should be added to it that aren't normally on it? I think that's more what I'm thinking toward.
Right. I mean, I think about all the commissions, all the commodity commissions.
Right.
So. Okay.
Deputy Director.
Thanks, Chair Holova, Vice Chair Lilac, members of the
You have to be
commission,
louder.
Green, Deputy Director. Thanks for the moment. Right now we're engaged concurrently as well in a rulemaking for clarifications and corrections on the climate friendly and equitable communities rulemaking. It's
Sorry, the Deputy Director, you have to be much louder.
Wow.
Yeah.
Okay. Sorry, thank you. So we're concurrently involved in a rulemaking with the climate friendly and equitable communities rulemaking, which is clarifications and corrections. Would you characterize this as kind of clarifications and corrections to goal 3 and goal 4 rules rather than really taking up the policy issues? I just want to sort of alert commission, if I could, that it's not sort of it's harder to redress. I think we should examine the working group members in the way that you're suggesting. Hillary made one point just a moment ago, which is pretty important. She's going to go over, I think, a schedule slide too, which is the speed at which she hopes to move in this, and then ask for rulemaking starting in January, though we know the policy agenda will be competitive. So we're all waiting to see that unfurl. Hillary mentioned folks with working knowledge of the agriculture and forest land programs, which is, I think, it shouldn't stop us from looking for a working group population that reflects the communities we serve and haven't yet served or haven't served. But I think I was just making a note that perhaps Director Bateman and I could meet with you and whoever else would like, Gordon, et cetera, to kind of look at that too. But if commissioners have suggestions of organizations or individuals, they're much appreciated. But it's kind of expected, I think in this case, it's sort of like the CFEC rulemaking, that folks are up to speed rather than looking at policy issues or redressing at this point. But I don't want to say, after this morning, I can't say we don't want to redress harm, because that was what just been spent the last 4 hours talking about. So I think we just need to kind of look at it fresh and kind of see what we're doing. But in the spirit of, sort of it's almost conforming rulemaking here. Thank you, Hillary. Thank you, Chair.
So thank you. And yes, I just want to clarify as well that it is very likely that we'll be coming back to the commission with a request for rulemaking in January as part of the recommendations for future action, right? And those recommendations for future action will likely involve like a suggestion that we also, in addition, consider more complex rulemakings. And we certainly intend that, during those phases, that there would be a much broader group included in a rulemaking advisory committee that it would be tackling those more complicated, policy issues. The intention with the working group is that it would be small and folks with familiarity with the history of the program, the case law underlying the program, and also coming at it from some different perspectives, as well as possessing that familiarity, so that we could rapidly produce the sort of set of recommendations that are around that, again, regulatory framework. And we aren't intending to take on any of the underlying policy issues associated with the program. Just want to make sure that's clear.
The other one I would ask about because the technical working group is beginning soon. I mean, that's see that beginning as early as next month. The only one that I and maybe it could fall under one of the advocate positions.
Yeah.
I'm just,
That's what it says to do on the picture.
Exactly. The picture does show it in my mouth. In anybody's mouth. Is wildlife. And I think about Eastern Oregon, both in terms of sage grouse and wolves, deer, the whole range, and just whatever the issues are, it can really impact a whole range of topics. So that's the only one that kind of jumps out at me. Well, maybe the only other one would be just wetlands Department of State Lands, just given water. But anyway, those are just a couple that
Yeah. Thank you very much, Commissioner Lulak. And we, had definitely considered our agencies, our sister agency partners who we interact with on a regular basis. So if there's a person at the Department of Fish and Wildlife that we, interact regularly on land use issues. And even the Department of Forestry, that I certainly anticipate when we take up issues that have a nexus with those other agencies, that they would be invited to participate and provide additional expertise on behalf of those agencies. So I'll talk about the schedule a little bit. So it is our intention to convene the first working group at the end of August. So in August, we are intending to publish a dedicated website to the project. My contact information will be available there throughout the process for taking public comment on anybody who's interested in it. In August, an announcement of the initiation of the scoping phase will go out to our Farm and Forest Improvement Gov Delivery channel, which has over 1,000 subscribers. Right. We intend that there'll be 4 technical working group meetings throughout the fall and early winter. Those meetings will be recorded and published on the dedicated project webpage. And then at the end of that process, staff will be preparing reports summarizing the process, those conversations, a finalized issues matrix, if you will, and then staff's recommendation for future action. The intent is to publish that report again on the webpage in December, and then follow that with some additional announcements soliciting public comment on the report. So that when staff prepares our staff report for commission in January, that public comment will be included and summarized in the staff report for commission at that time. And again, so the intent is to go through, this list of known issues, to really flesh it out, finalize it, and then provide food for thought on, how we can, as an agency, address these long-standing known issues with the program. And then again, in January, we'll be coming back to commission, with that and asking you, for feedback on proposals to take action, such as initiating a more simple, straightforward rulemaking. There might be other things like legislative concepts should the agency pursue. Other things might, recommend that we draft guidance documents as an agency, but those aren't legally binding. So there are a whole suite, not just rulemaking, of proposed things to address those issues. It might require additional data should the agency look into scoping in an effort to collect more data or do an analysis. So I anticipate that when we come back in January, we're going to have another conversation about these sort of ideas and how we can move forward with those at that time. And again, going forward into the future, I do anticipate that we'll come back with requests for rulemaking. And at those times, we could certainly go through the robust and super inclusive outreach for those rulemaking advisory committees.
Deputy Director. Thank you. I'm sorry. I really so full of thoughts about really reflecting on this morning and the Donation Land Act and folks that were left out of, the wealth building programs that come from sort of our agricultural and forest working lands management programs, maybe concurrently. So just a thought, I feel I might get smote down here, just making this random suggestion from the dais, but as we're in scoping, and working with a kind of focused technical work group on the technical really details, maybe concurrently we do some stakeholder interviews to really scope out what a more holistic look might be that would include redressing historic harms. So just thinking about some stakeholder interviews in this period, maybe conducted by your clone, because you'll be very busy during this period, but just so we don't miss an opportunity to set ourselves up well for a more robust rulemaking, that we're not thinking too small, too narrowly. Just a suggestion. Thank you.
Thank you to Deputy Director Green. Of course, this is a very important conversation, and how, the land conservation program intersects, with ideas of equity, of inclusivity, of fairness outside of a goal one process or community engagement, I think is a really interesting topic. And as I, sort of understand it, there are several issues that come up in those conversations. A lot of them have to do with ownership of land, access to training, particularly access to capital, and impact of practices. And in those conversations, as I've understand them or have participated in them, the intersection with our authority is limited in a lot of those topics. There are a few areas, where those conversations do intersect with our authority that have come up, and those are areas where I think we will be considering those questions throughout this process. An example of that, as I'm anticipating a question here, would be on minimum parcel sizes in those urban adjacent areas and affordability of farmland for beginning and marginalized farmers, right? So that is something that comes up frequently, and that we have looked into, a little bit as an agency in the past, and that is an issue that would be appropriate, to consider throughout this process where it intersects with our authority.
Thank you. And Hillary was the first one to fill out that equity framework for decision making that Commission passed in April with respect to this program. So I don't think you put it back in the server, so I look forward to reviewing it. It could become a doctoral thesis. These are big, big questions that I know Hillary's wrestling with. So thank you. And thank you, Chair and Commissioners, for bringing it up. Thanks.
Thank you.
I didn't know if you had more slides or.
So no. So again, in a nutshell, that is the intention of what we hope to accomplish in the next 6 months with this program. Happy to answer any additional questions from the Commission.
Commissioners, any questions? Commissioner Boyer? So, this is awesome. Thank you. And I look at my fellow commissioners, and they're probably not as well versed on this as I am. And I'm curious how you all feel about maybe keying us up to be prepared for that January conversation, to educate us and examine all the exemptions on agricultural land. I think it would really benefit us to, I don't want to, it's just examine them and understand them, because it's a lot. And I don't think you'd be prepared in January. So I'm thinking like maybe kind of working towards that the next couple of meetings, just not all, just kind of doing a few, or just kind of pick some out that you really want to learn more about, or
so is your thought that, sorry, because we have a November meeting, was your thought that
we only have
staff
one
would
more
present
don't even know what month we're in.
would just have a short presentation?
It is really only one more.
Yeah.
All right, let's do it in December.
Yeah.
Because I'm a believer that the urban growth boundaries got to work on both sides. So not just one side. So And I just think it would cue you guys up for the conversation in January if we could have this as an educational piece.
Director?
Chair, thank you. Brenda Bateman, Director of the Department. I think we've got a November meeting that we could do some informational work during that. But keep in mind as well that the January meeting would really just be a kickoff. It would be probably a charter or a charge, if that, depending on what we hear back from the technical committee and the report. And so we do have time to really marinate more in this subject. We don't have to panic in terms of being done in January or anything like that.
No, but I want to keep the momentum going. So
She knows way more than most of us, so she knows what we don't even know. We don't know yet.
I just think it would benefit my colleagues. Yeah. So
I'd also like to suggest that maybe we just do like a work session on it or something too. If we don't have time in the November agenda or January agenda, whenever that comes up, I think would behoove all of us probably to have that bigger conversation.
Commissioner Lazo?
Thank you, Chair. Thanks, Hillary. A couple thoughts. One is I just want to support what Deputy Director Green is saying about other perspectives that might inform even that technical working group. I think it's especially this sense that we may not know what we don't know, just what Commissioner Hall has said. And so there may be value there. I just wanted to support that. Another question I have is the intersection with what you said are the exemptions that are legislative, that we sort of don't have control over that, right? And so how does that intersect to the processes that we're going to go through and potentially the future of these? And we kind of got to this point based on that dynamic. And so is there any thought that that's a dynamic we could change?
Thank you very much, Commissioner Laszlo. So yes, so the uses permitted in exclusive farm use zone are set forth in statute, and we have the ability to clarify and interpret those uses. And so in some cases we do that, and in many cases we have not. So Steve will jump in and correct me viciously, I'm sure, if I'm overstepping here, but we do have that authority to clarify the intent behind them.
Vice Chair?
Well, I'm just going to say, I certainly don't know as much about farming as you do by any means, but as a former county planning director and having worked on this for a long time, it is interesting because some uses, like destination resorts, those standards are spelled out in statute. Others, there's a lot of flexibility and we have a lot of authority. And so it's really the purpose of the work session, the education session is to get a better understanding of where do we have that authority and where don't we? And then I guess my question is then, might you see, or the group, where there may be areas of common interest, could that become a potential legislative concept on behalf of the department to the governor's office to see if there's interest in, okay, maybe we should revisit any of these uses or certain uses, or the implementing statutes for a sub 1 or sub 2, but mostly a sub 2 use, because those are the ones with the conditional use standards in statute. So that is a possibility.
Yes, thank you, Commissioner Lilac. So we definitely anticipate as a possibility that we might come up with a recommendation that the department pursue legislative concept to address certain of these issues.
So to broaden our understanding, I believe we have maybe 16 people that are here to give public testimony. Yeah. And we have 3 minutes for each person providing testimony. If you can make it shorter, we'll appreciate that. But we did say 3 minutes before, so we don't want to cut you off in that way. And so I don't know if I have I have a list. I don't know if it's the most updated list, but I'll go with
I'll bring up the slides with.
Okay, we'll get a new list.
thank you, Hillary. Thank you.
Thank you.
Okay, we're first on the list is Roger Kay from Friends of Marion County. Virtually, he was supposed to be virtually, so let's see.
Hold on. Can you hear me now?
Yes.
Okay. How to find the right button. Anyhow, I distributed some brief comments to you that you should have in your packet. I hope that you've been able to review them. So I'm not going to read all of this information. Matter of fact, I'm going to try to condense my comments here. Anyway, I'm president of Friends of Marion County, and I submitted a review of staff decisions at your last meeting in April that support Robert Liberty's request to conduct a statewide review. So I want to briefly just touch on 4 cases that have been that we've had to appeal to court. The first one references number 1, which is a zone change. In this case, involved a zone change, comp plan change, and partition through an irrevocably committed exception. And LUBA found insufficient evidence because the applicant cited surrounding AR zone properties without showing evidence of impact from the AR properties to the EFU parcel. And then case number 2, commercial activity in conjunction with farm use. This case involved an education program unrelated to farm uses on EFU property, since the program was neither a customer or supplier of those farm uses. Case number 3, dwelling on high-value farmland for $800,000 standard. Staff and HO denied this application, but the Board of Commissioners approved it. We argued that the $80,000 standard in sales of Christmas trees for 2 consecutive years was not earned income because the trees could not be grown in a limited time, usually taking 5 to 7 years. And LUBA will decide this case on August 2nd. And the last was a home occupation case provided by the Marion County Commission as a legislative amendment, proposed events as home occupation on EFU for up to 750 persons per event, with multiple events permitted each year. And LUBA remanded, and the county did not appeal this case. So if you take a look at the 4 cases I'm presenting to you, you can see each one is in a different type of application. A zone change, commercial activity in conjunction with farm use, farm dwelling, and home occupation. And I think those are 4 cases which would exactly fit into the proposed review of the type that you're looking to undertake. And that's all I had. Thank you.
Thank you. Okay, next person giving testimony, Rod Park. And thank you, Roger, from Parks Wholesale Nursery in person.
Hey, thank you. So, Chair Holloway and Commissioners, I'll try to keep my remarks brief as I've turned in written testimony. As I said, my name is Rod Park. I'm a 3rd-generation farmer in the eastern portion of the Portland Metro region. I'm a past president of the Oregon Association of Nurseries. I'm a former chair of the Oregon Board of Agriculture. I've served 12 years as a Metro counselor. So I've kind of been around. I certainly carry certain scars from all those experiences. They certainly have informed and colored my views of Oregon's protection of farmland. Also the building of vibrant communities and how transportation is interwoven into the urban and rural landscape. The nursery industry is the largest segment of agriculture for the state of Oregon. 75% of it's exported. It's $1.3 billion. It's traded sector, just like your silicon chip manufacturing. Surprisingly, the most nursery production is in the same population counties, of Clackamas, Multnomah, Marion, Washington, Yamhill. And if you look at the nurseries, they're interwoven in and around urban growth boundaries of all those different locations. I will say most of my fellow farmers support the Oregon land use system, you're always going to find an outlier out there, just like in any situation. We know that without the land and the ability to use it, we cannot produce our plants. Unfortunate system in the Oregon nursery industry is it's under attack. There's a perceived need for additional land for silicon chips, and there's a lot of testimony that you'll probably hear later at some other date to the contrary. It's under attack from the well-intentioned but misplaced belief that adding land will result in affordable housing. It is under attack by the public use of natural areas abutting farmlands due to increased liability and farm restrictions. And that just has to do with liability issues in terms of farm chemicals and farm practices. It's under attack by the citing of urban uses placed in rural areas. Classic example is the city of Portland is trying to cite a water treatment plant in a rural area, indeed a rural reserve area approved by LCDC in 2013. Housing for non-farmers are being allowed, as mentioned earlier, in these farming areas. A person been contacted by someone who was trying to qualify EFU land for housing. He wanted to do a series of greenhouses to grow organic tomatoes to beat the $80,000 rule income test. And as he qualified each piece of property, he then wanted to move the greenhouses to the next piece of property and qualify that land. This needs to be addressed in this situation because unfortunately there is no penalty. There is no penalty once a house is constructed, it's in place. They don't lose their farm use assessment, and you end up with houses that in my current location, there is a 7,200 square foot house that's up for sale on 14.5 acres of EFU that is being hayed. And I would venture to guess the person who buying that would not be able to make it as a farmer. So my time has expired, so I will just say that I would seek clarity to the rules. I would also ask rules that preserve farm zones and their ability to produce Oregon's agricultural bounty. And I think that's the key to our sustainable future. So thank you.
Thank you. Thank you, Rod. Next up, Mickey Killingsworth from Jefferson County Farm Bureau, virtually.
Nikki, are you with us? I see you're still muted. We can't hear you.
Now, can you hear me?
Yes.
Thank you.
Okay, I'm Mickey Killingsworth. I'm the Secretary Treasurer, Jefferson County Farm Bureau, and I'll keep this short and brief. Every time this report comes out, our Farm Bureau goes through it with a fine tooth comb, and we cuss and we discuss and we try to find something positive about the report. This proposal is needed, has been needed for a long time. I hope it moves forward quickly. And this last legislative session that just ended was brutal on agriculture and trying to protect the EFU zone. And it seems every session it gets more brutal, as Mr. Parks referred to the semiconductors. All the farmers that worked really hard to stop the rape and violation of Goal 14. It was a brutal session. Our Farm Bureau views a lot of things as contaminants. And every time a non-farm activity is added, even though it may not be added by this body or the department, but is added by the legislature, it is an assault on the EFU zone, and they're contaminants and they bring problems to agriculture. And I'm sure you're going to get educated. Commissioner Bauer brought that up, which I think you, or Boyer, which I think you probably need to understand it the way she does. We're passionate about protecting our ag base. We have 58,000 irrigated acres when we have water. We're in our 5th year of a drought. But the key thing you need to understand, if the state of Oregon does not stabilize the ag lands and quit letting it be developed, there will be no future for the younger farmers to come in, because you have to have ag ground to farm to be farmers. And that is key. And everybody needs to understand that, instead of looking at us as, oh, it's always much cheaper to move out and develop land. And instead of rebuilding industrial sites that aren't being used, gray sites, or buy commercial areas and redevelop that. It's always cheaper to develop in virgin ag ground. And that's a problem. Don't know how to fix it, but it's a problem. And I'm laying that all at your feet. Just let you know, our Farm Bureau's here. We scream and holler and fight and do legal battles, just like every other person before me mentioned. But we're here. We're not going to go away. But the only thing that'll happen is when we die, because we don't have a stable land base. Thank you for your time.
Thank you, Mickey. Next up, we have Sheila Dooley, virtually.
Jan, would it be possible to get the people on Zoom on the screen so we can see them next time we have a Zoom?
Yeah, if you're participating virtually, you can turn your camera on.
Oh, okay. I can't find how to do that. Can you hear me okay?
Yes, we can hear you.
Okay, good. It just says the mute thing. I don't see how to how to do the camera on here. Sorry. Anyway, I'm Sheila Dooley. I live in Wasco County. I've been a longtime supporter of land use planning since the early 90s. The proliferation of non-farm dwellings in Wasco County is of particular concern to me. The criteria for allowing a non-farm dwelling in the exclusive farm use zone includes that the dwelling will not force a significant change or significantly increase the cost of accepted farm and forage practices on nearby lands. It will not materially alter the stability of the overall land use pattern in the area. And the dwelling's allotted parcel must be generally unsuited for farm use. It shall not be considered unsuitable for farm use due to size or location if it can be used in conjunction with other land. In Eastern Oregon, a parcel is considered suitable for farming if composed predominantly of class 1 through 6 soils. However, LUPA case law says that the soils in Eastern Oregon are not class 1 through 6, and the county doesn't have to consider if the parcel can be put to use with other parcels. I believe this is a misinterpretation of the rule for non-farm dwellings. And when you ask you to clarify that the county must consider whether the parcel can be put to use with other parcels in determining whether it's unsuitable for farm use. Relying on a soil survey when determining whether to allow a non-farm dwelling is concerning. In regards to soil assessments, DLC states that the county may make its own determination as to the accuracy and acceptability of the soils assessment. DLCD has reviewed the soils assessment for completeness only. There are only 5 soil scientists on the DLCD list of certified soil scientists who perform soil assessments. Last year in Wasco County, there was a situation in which 2 soil scientists came to contradictory conclusions regarding the same soil survey. One was hired by the applicant and one by the application opponents. Wasco County's Board of Commissioners arbitrarily selected one. Neither Wasco County or the planning department staff have the expertise to evaluate the results of a soil survey for accuracy. The fact that the soil professionals came to such different conclusions seems to indicate this is either not a reliable science or that there's perhaps incompetency or bias involved. In any case, these results should not be the basis for allowing non-farm dwelling or rezone. There is significant parcelization of farmland in South Wasco County as evidenced in the GIS map. These parcels are similarly vulnerable to a soils expert reclassifying a corner of these properties as class 7 or worse. Approval on all of these parcels will destabilize the agricultural land base. The non-farm dwelling criteria are difficult to address. It's difficult for an average citizen to make a case that a dwelling will force a significant change or significantly increase the cost of farming practices in nearby lands. Similarly, it's difficult to show they will materially alter the stability of the overall land use pattern of the area. I encourage DLC to find a way to address the soil scientist problem. Also provide guidelines for applying the stability standard and other criteria. Thank you for your consideration of my comments.
Thank
And
you.
I
Sheila.
put in writing, yeah, that's not as probably easier to read.
Thank you. Thank you
Okay,
for your
thanks.
comments. Thanks. Next up, we're going to have Carol Macbeth from Central Oregon Land Watch in person.
Good afternoon, commissioners. My name is Carol Macbeth. I'm a staff attorney at Central Oregon Land Watch. Thank you very much for the opportunity to comment today on behalf of Land Watch. I wanted to echo Ms. Dooley's comments. Land Watch is also very concerned with the non-farm dwelling proliferation across the state, and in particular with the use conjunction standard. We echo her concern that all counties should be made to consider whether land could be used in conjunction with other land. I think that is quite clear from the legislative history of the use conjunction standard. It comes from an early decision from 1977, and in a task force in 1983, the legislature decided to incorporate that decision into the non-farm dwelling standard. And the holding of the case was just because a parcel is small, if it's surrounded by working farms and you could be using it with that, then you can't say, well, we can't put this to farm use. That's called the use in conjunction standard. And the whole point of it is that if you can use it with other land, then it's not unsuitable just because it's too small. But as Ms. Dooley was pointing out, that it simply isn't being interpreted like that. And it's interesting because for many decades, LUBA did interpret it, just as we've said, that the whole point is that you could use it with other lands. And so you have to go ahead and protect it. If you could, like if they're just a little part of a field and if they're farming the rest of the field, why can't you use it with that? So now the counties have it turned around and they're saying, oh, well, we don't have to look at that, and they don't, and LUBA has upheld them. So having hit our head against a brick wall a couple of times at LUBA trying to get it changed, we come to you and ask you to change it. And if the working group would like any help with that, Land Watch stands ready to do that. We have some suggested language that would make a one-sentence fix very simply to what we believe would be to put into place the legislative intent of that provision. I was just going to say that we are co-appellants, as you'll probably remember, with DLCD on a 710-acre subdivision in Central Oregon called Eden Central. And at the heart of that is the definition of agricultural land. Deschutes County keeps making, we believe, the wrong interpretation of agricultural land. The definition, which comes from 1975, the LCDC made the definition of agricultural land and a scientific objective definition from the Natural Resources Conservation Service. So, yeah, that was the classes 1 through 6. You probably heard of the land capability classes. Class 1 is like river bottom soil, like in the Willamette Valley. Class 6 is from hillsides. It's actually class 1 starts at the river, and class 8 is the very top of hills where everything turns to stone. So you there's 1, 2, 3, 4 as you go up the hill. So 6 is around here, but it's also like a high plateau where the soils are thin, and it's really suited for grazing because the grasses don't have to be so deeply rooted. Anyway, class 1 through 6 from the river bottom up the hill in Eastern Oregon, that's considered farmland or agricultural land. But the count and that's a matter of law. So for Deschutes County to find out on Eden Central with this 710-acre subdivision, for them to find out, is this land agricultural land, all they had to do was go to their bookshelf, take out the NRCS land capability, look it up, see that it's class 6, close the book, put it back and say stamped agricultural, because that's all it is. It's a matter of law, that's called. It's just in the law. But the second part of the definition is, can it be used for farm use? Because land that can be used for farm use is also protected as agricultural land. The counties, we think, are mixing that up, and they think that all of it is their opinion. It's all up to them. They can weigh soils evidence. They can ask for evidence from people and say, do you think it's farm use? Do you think it's farm use? They can do that for the second part of the definition. The first part is a matter of law. We think if LCDC could consider clarifying that point, that we would get a long way. I mean, instead of spending 9 months litigating something like that, again, it'd just be a matter of looking it up, stamping it agricultural. And that is what used to happen even 10 years ago. And it's just gotten so that each time agricultural land comes up, the counties are, well, at least in Central Oregon, the counties are acting as though it's something that's within their discretion. I'd be happy to answer any questions you may have.
Thank you, Carol.
Thank you.
Next up, David Vanashe from Vanashe Farms LLC. He's on virtually.
Okay, can you hear me? See me?
Yes, we can hear you.
Okay, my name is Dave Van Ash and I live in Washington County. I'm between the Sunset Highway and Cornelius, Forest Grove and Hillsborough. And I'm here to talk about the threat of the threats to farmland in Washington County. And I agree with all the other farmers that have spoken in regard to the rest of the state. So I and my wife, we are fourth generation. My son who's with us is fifth generation. Farm was established in 1896. When I and my wife took over, my parents owned about 150 acres. We now own 1,028 acres, and we farm 2,350 acres with 25 landlords. Crops, grass seed, clover seed, wheat, and hazelnuts. About 25% of it is irrigated through the Bureau Reclamation, Tualatin Valley Irrigation District, Scoggins Dam, and Forest Grove. I've been a supporter of Senate Bill 100 since I was 25 years old. I'm 74. So it's protected Washington County farmers for that length of time, 50 years. I'm a member of Thousand Friends of Oregon's Land Use Committee, Oregon Farm Bureau's Land Use Committee. I've been Washington County Farm Bureau president. I've been involved in the Metro Urban Rural process. Washington County and Willamette Valley is one of the greatest ag lands in the world. There's 200 different crops you can raise here. We're the small seed capital of the world, grass seed, clover seed. Why? Because we have deep soils, 40 inches of rainfall, a mild intercoastal climate. Portland is a major wheat shipping point in the U.S. And Washington County is the hub of ag in the northwest corner of Oregon. And this county serves North Yam Hill, Tillamook, Clatsop, Columbia, Multnomah, and Southwest Washington. This is where all the equipment dealers, fertilizer dealers, seed cleaners, hazelnut processors are located. And so all those other counties depend on this county for ag infrastructure. Now to the threats. Urban expansion onto EFU high value farmland. We have all the other problems in EFU too, but urban expansion has been one of our main threats. We created the urban rural reserves. Metro did that, and we supposedly have a 40 to 50 year supply of land, and it's going away fast. We have the satellite cities of North Plains, Banks, Gaston, all wanting more land, particularly North Plains. I thank you very much. Our family is not in this for money. It's not the most important thing in our life. If it was, we'd sell our 1,000 acres and stop farming and move to paradise, wherever that might be. We've been here for 127 years. We have succession plans to continue for another 127 years. So please help us. Thank you.
Thank you, David, for your testimony. Next up is Rob Halliburton from Friends of Yamhill County, and he's in person.
Chair, Chair Oliver, Commission. Good afternoon. My name is Rob Halliburton. I'm here representing Friends of Yamhill County. Friends of Yamhill County is a nonprofit advocacy group that works to protect natural resources through the implementation of the land use planning goals, policies, and laws that will maintain and improve the present and future quality of life in Yamhill County for both urban and rural residents. I helped administer the Oregon's exclusive farm use regulations for 13 years as a county planner, and then broadened my geographic perspective at DLCD for nearly 20 years, first as a regional representative and then as a division manager. While I had a statewide perspective during my time at DLCD, my comments today are focused on Yamhill County. EFU zoning is meant to protect farmland and farming by maintaining large blocks of land in agriculture, by preventing unnecessary conversion of farmland to other uses, by preventing non-farm uses that conflict with farming activities, and by maintaining farmland values at economically viable levels. In Yamhill County, a vast majority of the land that was zoned to EFU at acknowledgement still carries that designation and is still available for farming. We have, however, been experiencing a proliferation of non-farm uses relating primarily to tourism. Yamhill County is well known for its wine industry, and that has been a magnet for a variety of businesses in EFU zones looking to profit from wine tourism traffic. These include hotels masquerading as home occupations, breweries and distilleries with no rational tie to the land, event venues for weddings and other large gatherings unrelated to agriculture, and quasi-restaurants. Agritourism events are also multiplying at a rapid rate. Some of these tourism uses happen at winery tasting rooms, but many are unaffiliated with a vineyard or winery. Some have a slender connection to farming that is then bootstrapped into unrelated activities. The proliferation of these uses both introduces conflicts with farm uses and increases the value of land beyond what an actual farmer can profitably pay. While we have a number of disagreements with the county regarding how the current regulations get applied, other uses that our organization finds inappropriate for maintaining a viable agricultural industry are unarguably permitted by those regulations. We believe the rules for short-term rentals as home occupations in EFU zones need to be better defined and strengthened. The allowances for events at wineries and wine tasting rooms are more expansive than for agritourism events at other locations in EFU zones, and too expansive in our view. The case law for commercial activities in conjunction with farm use would be applied more uniformly if it was reflected in the rule. While some of the law regarding these uses reside in statute, the commission has broad authority to further protect agriculture, as you heard from your staff, particularly on high-value farmland. We request the commission consider doing so.
Thank you, Rob.
Thank you.
And so for the rest of the folks testifying, I don't have your affiliation. So if you could say if you're representing somebody or yourself. And so the first one up is Chad Allen. Chad Allen has.
Chad is unavailable.
Okay, the next one is Paul Harcum.
Yes, can you hear me?
Yes.
My name is Paul Harcum. I live in rural Lynn County, not far from Albany. I have a 12-acre farm where I grow staple crops for direct sales to customers and local farmers markets. I'm here today to represent Friends of Lynn County. And I would like to say that, well, Friends of Lynn County came together shortly after Senate Bill 100 was implemented in the 1970s and has been fighting ever since to protect the land base for farm, forest, and wildlife resources. Our experience is certainly consistent with everybody else's that stricter LCDC rules are long overdue. And so we commend the leadership for initiating the Farm and Forest Conservation Program Improvement Plan, and we're grateful for this opportunity to comment. First of all, on our list of issues is the land swap provision of OAR 660-024-0070. The city of Millersburg, as you must know, has invoked this in an attempt to incorporate 170 acres of prime farmland into their exclusive farm use zone by setting up a swap with a nearby abandoned industrial site. It's the proposed, it completely ignores the fact that these two sites are in no way equivalent in terms of their present condition or future capacity for agriculture. A simple rule change to expand the scope of the equivalency criteria could prevent de facto expansions of the UGB. Also in this case, there's a significant amount of undeveloped industrial land inside the Millersburg boundary, which they are not required to consider since this is a land swap, we believe that this is not the intended outcome of the swap rule, where there is an available land within a UGB for industrial development. Another issue that we face in Lynn County is addition of residences in the mixed farm forest zone through manipulation of the alternative dwelling statute. By gaining a conditional use permit for an alternative forest dwelling, followed by a property line adjustment, landowners have partitioned off dwellings into small acreage parcels to sell with no requirement that it be managed as farmland. Eliminating or restricting the non-farm dwellings option in applications for a property line adjustment in an EFU or farm forest zone could curtail this bait and switch tactic. We urge the working group to consider these issues in scoping your plans for revision. Thank you.
Thank you, Paul. Next up is Libby Wilson.
I'm not seeing that Libby is with us.
Okay. Next up after that is Dave, maybe Nofkinger singer. Okay.
Thank you for your time today. My name is Dave Nofziger. I'm a third generation farmer of 23 years. I am honored and blessed to have the opportunity to farm the family farm with my wife and continue to provide food for the community. I currently farm 260 acres. 60 acres of this is being leased. Our farm is bordered by the Willamette River to the south and the city of Millersburg to the east. It is directly north of the 160-acre parcel that was proposed to be rezoned industrial using the UGB swap criteria. None of my farm is contiguous, and the average field size is 30 acres. The community I farm in has produced over 72 different crops. I strongly support exclusive farm use zoning for agricultural land. There's a limited amount of good farmland available in our community. We have ground that is considered nationally significant, or land best suited for growing food. We are seeing this land disappear around us every day. The mere opportunity to develop these parcels drives up land prices, making it unavailable for farmers to lease or purchase to incorporate in their operations. In our farming community, the city of Millersburg proposed and approved a UGB swap of 160 acres. The city deemed a piece of industrial land within the city limit unbuildable. The proposal was to swap industrial land within their city limit with 160 acres of exclusive farm use land west of the city limits. That land would be rezoned to industrial and moved into the city limits. The ground proposed to be rezoned has a long history of producing high value, high yielding crops. This land is a vital part of the large block of ag land that makes up the area's commercial ag enterprise. The city of Millersburg felt like they met the UGB like for like criteria, but other than swapping the same amount of land, there was nothing like for like about the two land parcels. The land within the city limits that they propose to be rezoned into EFU is not farmable. The land is covered in water over 6 months of the year. The land has ridges and ravines that would make it essentially unfarmable. It is west of the effluent ponds of the old paper mill and south of ATI's Superfund site. This parcel is also downstream from ATI's Superfund site. The soil drains poorly, which has led to reed canary grass growing throughout the parcel, which chokes out other vegetation and is very difficult to control. This land is low-lying wetland and is part of the Willamette River Greenway. The city found these were comparable properties within the standards of LCDC's UGB swap provisions. DLCD staff agreed. The ag community and others were successful in defeating this swap at the local level, but it was on the basis of local plan revision, not LCDC's UGB swap rule. Through local testimony and support at the Lynn County Planning Commission meetings and county commissioner meetings at the county level, the application for the UGB swap from the city of Millersburg was denied. The city pulled their application prior to the commissioners putting together their findings for the public. Millersburg is bringing this issue to DLCD. If the swap had gone through, it would have driven a huge wedge into an intact, large block of agricultural land that supports the area's commercial ag enterprise, destabilizing the land base and industry that depends on it. The city of Millersburg currently has over 400 acres of buildable land inventoried within the city limits. They still tried to go for the land swap. While this testimony is specific to my experience with the UGB swap, I appreciate this issue being addressed. Many hours have been spent by myself, my wife, and farmers in our community researching land use laws, reviewing the city's comprehensive plan, writing and presenting testimony. While I learned from this experience, my time may be better spent farming and trusting the land use laws will support agriculture. Myself and my community ask LCDC to amend the UGB swap rule to prevent this from happening again.
Thank you, Dave.
Thank you.
Next up, I think it's Jackie Jones.
Good afternoon, commissioners. My name is Jackie Dyke Jones. I'm a farmer in Washington County. I farm in Roy, Banks, and North Plains. Fourth generation farmer, farming with my dad. We raise Catawba blackberries, blueberries, grass seed, sometimes rotate wheat or sugar beet seeds or clovers. I love being a farmer. It is a lot of hard work and very fulfilling to feed and fuel Oregon, the United States, and beyond. I'm a steward of the land with my other fellow farmers. Today, I'm here to ask for your support and to express my support for the technical working group and to ask you to help us be a steward of the land and be with us. Help us keep Oregon green. There are so many threats to our agriculture community, not just the land, but everything around us. This last legislative session was very hard and taxing on all of us involved to protect farmland that we farm or that's next door. Farmland is continually being treated or perceived as if it were disposable, but it is finite. There is no farmland available. I'm speaking from the heart because with North Plains about to put in their UGB proposal, I am constantly begging and trying to tell the story that agriculture should not be traded for industry, that everything chipping away at our finite resources, feeding, fueling, providing fresh air, capturing carbon, and impacting our livelihoods should not be taken for granted. I've looked at the map viewer and I've seen what's at stake. Agriculture is one of the most culturally relevant and inclusive industries around. Food brings everyone together. Nature brings everyone together. Thank you for your hard work on this issue and helping keep Oregon green. And again, please be a steward of the land with us.
Thank you, Jackie.
I will, since I do have a couple seconds, say that everyone is invited to come out to Washington County to visit both Dave Van Ash and myself.
And I'm right here with Jackie. One thing that I did not mention is traffic. Traffic is deadly for us out here. Our quality of life is constantly being diminished. And a lot of it has to do with traffic, just commuter traffic. It's terrible.
Thank you, everyone.
Thank you. And I sort of wanted to pause for a second to say, because our list is long, I'm being very efficient. Doesn't mean that I'm not listening. Doesn't mean we're not listening. So I don't have time after each person to say more flourishes in that regard, but we are all intently listening. We have 3 more folks giving testimony. So the next one up is Robert Liberty.
Members of the commission, good afternoon. I'm Robert Liberty. I'm representing myself. I reside at 3431A Southeast Tibbet Street. For those of you who care about housing, you know why there's an A on our address, because we have an accessory dwelling unit we rent for long-term housing at below market rates. Director Bateman, Hillary Foote, and Gordon Howard deserve our thanks for their impressive leadership on this issue. Let me begin with the big picture, and the big picture is the entire planet. In the global context, Oregon and Oregonians occupy a privileged position of natural resource wealth compared to most people and most places on Earth. Population growth, increasing wealth globally, urbanization, political instability, and climate change are simultaneously pressing on our finite supplies of land and water, putting food supplies, fiber supplies at risk. Our privileged position in Oregon as Oregonians imposes on us a special responsibility to act as stewards of those resources and not throw them away to satisfy non-essential wants like second homes and tourist attractions instead of serving basic needs. Second, we need to take into account a phenomena that did not exist 50 years ago, rural gentrification and displacement. Across Oregon, people of great wealth are buying land and building trophy homes, displacing not just people, but jobs, and eroding our social connections as well as our land base. Now, some more specific thoughts. Since 1983, 34,000 new homes have been built in exclusive farm use in Forest Sounds. That's enough homes to house the population of Medford, or Bend, or Springfield, or Tigard plus Wilsonville. Those homes are not evenly distributed. They're concentrated in certain areas of the state. The same thing is happening with commercial uses that are not really in conjunction with farm use and land divisions. Land divisions increase prices per acre beyond what farmers or ranchers can afford and create parcels that are too small to efficiently farm, ranch, or carry out forestry. And in those areas, it's potentially the cumulative effects can be the collapse of the farm economy, which has happened in Clark County, Washington. Land is finite. Demand for land development is infinite. In these areas, especially areas of high value farmland and prime forest land, I submit we need to turn the valve off, not just tinker with criteria. We have 50 years of experience with how some counties can manipulate or ignore even the clearest criteria. In those areas, enough is enough. And in other areas of the state, we need to cut back on authorized uses and tighten up the standards. Some of these changes are squarely within your authority, as your staff has noted, but in other cases, they will require legislation. I hope, and it sounds like you will make the extra effort to document the need for legislative changes needed to realize the goals of Oregon's planning program that are even more relevant today than a half century ago. Thank you for your service, and I mean that.
Thank you, Robert. Up next, we have Blair Batson in person.
Good afternoon, Chair Holova and members of the commission. It's nice to see you. My name is Blair Batson. I'm a staff attorney with 1000 Friends of Oregon. We're a land use watchdog that have been around for almost 50 years, just after the program. Thank you for the opportunity to testify today. 1000 Friends strongly supports the department's decision to address needed improvements to the agency's Farm and Forest Land Conservation Program, starting with ag land. It's been 30 years since the agency has taken the opportunity to review how the program is working. Improvements are needed, as you've heard from many witnesses today. It's important to keep in mind that behind this need to protect agricultural land is that agriculture brings big money into Oregon. The Oregon Department of Agriculture reports that production agriculture and its associated industries contributes over $30 billion to the state's economy. This represents over 15% of the total state economy and 20.3% of the state's workforce. That's 1 in every 5 jobs. And the people in that industry are pioneer families to recent immigrants. There's a vast range, a very diverse group of people who are employed by agriculture. I wanted to take a second because most people have addressed the actual issues that are going on. There's been the question of your authority, and your staff has appropriately said you have broad authority. And I just want to mention, I was part of a lawsuit that challenged your rules on high value farmland 30 years ago. And your wonderful attorney then, one of Steve's predecessors, and I went to the Oregon Supreme Court defending LCDC's authority to adopt rules that limited and even prohibited some uses on high value farmland within the exclusive farm use zone. And the rationale was that the legislature's grant of authority to LCDC is under Chapter 197. I'm not going to get too technical, but LCDC, when it adopted Goal 3 way back in the dark ages, made the choice to make the optional EFU zoning mandatory. So you have the authority to say that certain uses are not allowed in certain parts of the EFU zone. Now, I told Steve that I gave him a very fascinating memorandum talking about that, because nobody's talked about this case in 30 years because it hadn't been an issue. So it's something you need to think about, consider. You may, you have big policy questions to make, but you need to feel comfortable that you have the authority to do what you feel you need to do on a policy basis. So with that, I want to say again, thank you. We're thrilled that you're entering this effort. We look forward to being a resource for you for any sort of questions you have, legal or technical, policy-wise, and we just applaud your efforts. So thank you.
Thank you. Thank you, Blair. And last up is Jim Johnson. Okay. Yeah. Is there Jim McCarthy? But I didn't, sorry, the Jim Johnson.
Is that all right?
Yes. Yes, yes. I just didn't know if there was a Jim Johnson. Oh, you are the Jim Johnson. Okay. No. I was, there we go, in the background.
Jim Johnson is here and he wants to be last.
Okay.
And now this is a privileged time at 5:07. My name is Mike McCarthy. I farm in Parkdale. I raise apples, pears, and cherries, and good afternoon to you all. I made the offer to Hillary Foote that I wanted to share with you 43 years of my land use experience, but she never took me up on that. And I don't think 5:07 is a good time to start on that, but I have worked in land use in Oregon for 43 years now. It started, I live in Parkdale, which really is sort of ground zero, Hood River County, of a lot of these issues we've talked about. I'm not going to go into them in a lot of detail because these farmers before me and Robert Liberty and Blair brought up some of the very key issues. But I've served on a DLCD committee a number of years ago that set the $80,000 test, which when we did it, we put an escalator clause in it, which made sense. That was taken out. That's one change you could make in rulemaking. I've also been in a group called Ag for Oregon, which was started by Hector McPherson and Lois and forgot his name now, Lois Carnegie. Anyway, that was an organization, pro-farmer, pro-land use group. Also been in the Hood River Valley Residents Committee in Hood River County, which has supported land use for 43 years. And I started to say I got involved a number of years ago because a destination resort was proposed near our farm in Parkdale, 1,000-acre destination resort. The developer had the gall to map our farm on that development and thought he was going to put his golf course on our property. And then he met my mom, and 43 years later, there's no destination resort. So, but Hood River County farmland, all would be gone. All of it would be gone by now without the Oregon land use system. But it's in very serious jeopardy because of all these little things that were, all these little cracks in the system. And one note about Hood River County, talking about global issues and the future of farming, Hood River County grows 30% of the fairs that are grown in the United States. We grow more food per acre than any county in Oregon. And I hope somebody will challenge me on that. But we grow more food per acre than any county in Oregon, which also means almost any county in the United States, we grow more food per acre, nutritious food. And, you know, Robert brought up the idea of climate. We have to continue to think about this. This is where food's going to be grown right here. It's not going to be grown in Arizona at 118 degrees. So this is part of the whole package of the land use system. The other issue that was brought up by Deputy Director Green was the equity issue. Right now, what I see in Hood River County is if you have $50 million, you hire the best attorneys in Portland. They go to the planning department. The planning department is afraid to do anything but say yes, which means that people with money and power get what they want. People who don't have money and power don't get anything approved. The other thing about equity is that as farmland gets more expensive, my Hispanic friends in Hood River County cannot buy farmland. They're leasing a lot of farmland because there's a lot of wealthy people that come to Hood River and don't want to mess with farming because it's dirty work and you don't make a lot. So there's a lot of land to lease. A lot of my Hispanic friends are trying to lease land. Some of them are going to work into lease purchase options. The only way that land is affordable for them is if we reduce the uses. And I can tell a lot of stories about real challenges. I want to just say one finishing thing. I've been in a land use group in Hood River County. Counties have too much discretion. And as an example of that, our land use group has taken Hood River County to LUBA 10 times. We've won 9 times. That means they're wrong 90% of the time. And I think that's something I hope you'll look at because there's not enough money. I don't have enough time. I'm getting older and older to fight these battles. It has to be clear. There have to be clear rules and they're not very clear. So anyway, I appreciate your work. I hope that we can communicate more about this as we go through this process of rulemaking because, well, it's very important to me. I know where all the skeletons are and I would love to discuss them with you at length. So thank you very much.
Thank you. Sorry about the not having you on my list here. So I think final testimony or discussion, anybody else? Just in case. Okay.
Good evening, commissioners. My name is Jim Johnson. I'm the Land Use and Water Planning Coordinator for the Oregon Department of Agriculture. Just as an introduction, because I only know a couple of you, I've been doing farmland protection in Oregon for 40 years. I was a county planner first, then I was on staff at the Columbia River Gorge Commission. The original staff did all the farm and forest land development for that. I was on DLCD staff. I was actually the first farm and forest coordinator for DLCD. There was farm people and there were forest people before me, but not farm and forest. I've been at the Department of Agriculture now for 27 years. You've heard a lot today. This is the kind of, I hear this every day in my position. I have really close connections with the ag community. They are very passionate about agriculture as a economic asset, as a cultural asset, as a part of what Oregon really is. Without going through everything that you've heard today, I do want to touch on a few of the issues because I hear them every day. I would say that in my 40 years of working in Oregon agricultural land protection, I haven't seen as great an assault on farmland protection as I've seen in the last 10 years. I was involved. I was the staff person at DLCD that actually drafted the $80,000 test, for example. And it was in its time, it was a great element in rulemaking. But there's so many things that need to be better defined, need to be better fleshed out that are going to court, and land use planning doesn't belong in court. It belongs in plans and rules and like, and we need to go there. I miss my carpooling with Mr. Shipsey so that we could discuss these things, but COVID kind of shot that to whatever. So real quick, agriculture, there's really two issue areas that we deal with in terms of the concerns that we relate to impacts to agriculture. One is conversion, loss of land base. The other is the ability to operate, the practices and the like. And those are both land use issues. Without the land, of course, we're not going to have anything, but without the ability to operate, That's just as important as having the land base. And of course, we can get into a whole nother discussion of water, but I'll leave that for another time. The cumulative impact of the 50 some odd non-farm uses that may be allowed in the quote unquote exclusive farm use zone is dramatic. And we really need to better address that. And it's not just a matter of saying we should have 40 uses instead of 50. And maybe I would probably support that too, but that's a whole nother discussion. We have so many issues in implementing the exclusive farm use zone related to simple things like definition. What is a park? What is a home occupation? What is a commercial use in conjunction with farm use? Believe me, there's so much venue shopping going on nowadays in land use. If I can't get approved as a tourism event, then we'll go and try and get it approved as a home occupation, or we'll go and try to get it approved as a commercial use in conjunction with farm use. In my land use classes that I learned in college, I was always taught that if you're called out as a specific use in the zoning code and you're denied, you can't go and get it approved as something else. You've got some requirements to meet, and that's that. That's not how it's working in the exclusive farm use zone nowadays. So we need to better define several types of land uses in the exclusive farm use zone: home occupations, commercial use in conjunction with farm use. There's a whole list. What's a park? You wouldn't believe some of the things I've heard people try to say is a park in an exclusive farm use zone over my career. And the first step is to codify case law. We had one of the most important cases in my experience in land use just happened in the last 5 or 6 years. Stop the Dump versus Yamhill County. It basically set the standard for how to define and how to operate the farm impacts test, ORS 215-296. Yet when I go out and talk to county planning departments, and I go out and give my EFU 101 class all the time, they don't even know about the Stop the Dump case. They're surprised. Gee, we didn't even know that existed. This is one of the land use cases that I've worked with in my career, and they don't know about it. We need to codify the case law. There's plenty of case law things going on in terms of agritourism events, in terms of home occupations and the like. We need to codify that. That's the first step. Then we need to better define these terms. And this is one of the reasons I strongly support your staff's proposal to get into this work and to develop this. Beyond the non-farm uses, and believe me, I could talk about them for hours. This whole issue of what is and isn't agricultural land, the definition under goal 3 of what is agricultural land, and Carol Macbeth brought this up, but it really gets down to the term non-resource lands. And a lot of counties are trying to approve rezones of land, saying it's just not agricultural land by definition. I am probably considered, and I don't like to talk about my ability, I'm probably considered the expert on spatial analysis determining on what agricultural land is. And I don't know how many times I've dealt with proposals to rezone land in this state that are just totally off the wall, but still get approved. So it's something that we really need to take a look at. And I'm going to try to speed up here.
You're over your time.
Lastly, and I was at a meeting Tuesday night down in the South Willamette Valley Energy Facility Siting Council meeting relating to a proposal to site an 1,800 acre solar farm. And I don't like to use the term solar farm because it's not a farm. So solar facility on high value farmland. The room was out the door. There was probably 100 people in a room made for 50 people. And yet we're proposing to basically convert 1,800 acres of land, high value farmland, to an energy facility site that is land dependent. Agriculture is not only land dependent, it is soil dependent. We need quality soils, we need water and the like. And without us looking at some of these issues related to alternatives analyses and the reasons to be cited and the like, agriculture is always going to be last in line. I'm going to leave it at that. Again, I strongly support a scoping group that your staff's proposing, and the Department of Agriculture would be very happy to participate. I also would like to invite any of you that would like to come to the Board of Agriculture's meeting next month. I will be giving a presentation, and I've invited Hillary to be involved in that, and regarding tourism activities and their impacts to Oregon's agricultural lands. Thank you very much.
Thank you. Thanks for being with us. So one of the themes of today's is definitions. We were just talking about that before everyone testified. I didn't know if we wanted to talk at all about any of this, or just take it in, and we'll have a lot more to talk about from now till January. But Vice Chair?
Yeah, the scoping is going to be critical, and I think the educational session will be incredibly important. A couple of the issues that I heard about too are some emerging issues that aren't in statute, that are just in case law, and it'll be interesting not to get into these today, but at a later time. One is short-term rentals, and how might that be addressed in this or another? I don't know. And then the other one was the UGB land swap that we were made aware of. I think I don't recall if it was January or April, but it was one of those. And I know it's been resolved at this point, but still that could happen again in the future. So, and I don't know what our discretion is. And I'm not seeking an answer for that now, but I'm sure there are other issues as well that'll just be helpful for us to learn about as we begin this process. And I think, especially as I look at Commissioner Warren, as we were the co-liaisons to the Climate Friendly and Equitable Communities Rulemaking Advisory Committee, we thought that was a big project. This could be far greater, and so the scoping will be critical, and maybe it's phased, et cetera. So a lot of work ahead. Thank you.
Commissioner Boyer.
Yeah, I just want to thank everybody for coming out today. I really appreciate you being engaged in informing us and help educate us. I always love the public process, so I really appreciate you all coming out. But one of the areas, I think about is the home occupancy, because I think the original intent is lost. I think so. It's the definition again. That is what we keep coming back to. So I really look forward to this process. It's long overdue. So thanks.
Yeah, I just want to say thank you to all of you who showed up to testify today. I mean, it's clear how passionate you are about this, especially since we're not taking any formal action at this point in time to even do anything. So just the fact that you are paying attention, you're here, really means a lot to me. And just know that I heard every one of you, and look forward to working through this process for the next couple of years.
Chair.
Yes, Director.
Chair, thank you. For just a note, wanted to harken back to an earlier report from this meeting, agenda item 4, which is commission business. And one of the attachments on there is the matrix of commissioner responsibilities. I don't know that we specifically called it out at that time, but we have asked Commissioner Boyer to be our liaison, and she has accepted. Do you remember that? To this very effort here. Just thought I should say that out loud and remind you. It's going to be good. Thank you.
I'd be honored. Thank you.
Yeah, sure. I think I'm particularly interested in the education piece leading up to this, given that we've heard, like you said, pieces of this. It's my 5 years I've been on the question, so I've heard pieces of it over time, but kind of encapsulating that, and then starting to understand, like you said, what's our role in this or not, and what are the kind of options for action, I think are important. So, yeah, thank you. So that concludes our last agenda item for today. We're going to recess the meeting from now until 8:20 a.m. tomorrow, where we will begin with item number 11. Executive session is closed to the public, which executive sessions at what time? Oh, 8:20. Okay, so the first item is at 8:20, which is executive session, which is closed to the public. After that is agenda item 12, which is climate friendly and equitable communities public hearing on clarifications, corrections, and adjustments with Bill Holstrom, Land Use and Transportation Planning Coordinator at 9:10 a.m. So at 9:10 a.m. we will be back open to the public. I want to thank you, and this concludes Thursday of our July hearing. Thanks.